Hello everyone, and welcome back. Today, we're diving deep into a crucial part of the Indian Constitution, Part 6, which deals with the structure and functioning of state governments. From the governor to the high courts, this part lays out the entire machinery that runs our states. It's a long one, covering Articles 152 to 237. So let's get started. First up, Article 152. It simply defines what the term state means within Part 6. Originally, it excluded Jammu and Kashmir. But after the changes in 2019, this part now applies to all states, bringing uniformity. Now, let's move into the heart of the state executive. From Articles 153 to 167, Article 153 kicks things off by stating that every state must have a governor. Interestingly, the same person can be appointed as the governor for 2 or more states, but a governor's power isn't absolute. The landmark case of Rameshwar Prasad versus the Union of India in 2006 established that a governor cannot act arbitrarily, especially when a new government is being formed. Article 154 vests the executive power of the state in the governor. This power is exercised either directly by the governor or through officers subordinate to him. However, the 1974 case of Shamsher Singh versus the state of Punjab clarified that the governor is merely a constitutional head, acting on the advice of the Council of Ministers. So, who appoints the governor? Article 155 tells us the governor is appointed by the President of India. This appointment process has also been scrutinized by the judiciary. In the BP Singhal case of 2010, the Supreme Court ruled that the president cannot remove a governor arbitrarily just because their political ideology differs from the central government's. What about their term? Article 156 sets the term of office for a governor at 5 years. But a crucial point here is that the governor holds office at the pleasure of the president, meaning they can be removed earlier. Again, the BP Singhal case emphasized that this power of removal shouldn't be used arbitrarily. To become a governor, Article 157 lays down to simple qualifications. You must be a citizen of India and be at least 35 years old. Article 158 adds conditions to the office, stating that a governor cannot hold any other office of profit and is entitled to an official residence and salary determined by Parliament. Article 159 requires the governor to take an oath to preserve, protect, and defend the Constitution and the law. Sometimes unexpected situations arise. Article 160 gives the President the power to assign special duties to the governor in any contingency not covered by the Constitution. The governor also has significant judicial powers. Article 161 grants the governor the power to pardon, reprieve, or remit punishments for offenses against state laws. However, the Maru Ram case in 1980 clarified that this power of executive clemency must be exercised with reason and not on a whim. Article 162 defines the extent of the state's executive power, which aligns with the matters on which the state legislature can make laws. This was a key point in the famous Nabam Rebia case of 2016, which ruled that a governor cannot interfere in the executive functions of the state. Now, let's talk about the real power center, the Council of Ministers. Article 163 states that there shall be a Council of Ministers with the Chief Minister at its head to aid and advise the governor. The Shamsher Singh case reaffirmed that this ministerial advice is generally binding on the governor, except where the Constitution grants discretionary powers. Article 164 deals with the appointment of the Chief Minister and other ministers. The governor appoints the Chief Minister, and on the CM's advice, appoints the other ministers. A crucial rule here, highlighted in the SR Choudhury case of 2001, is that any minister who is not a member of the state legislature must get elected to a seat within 6 months to continue in office. Every state also has a highest law officer, the Advocate General, appointed by the governor under Article 165. They advise the state government on legal matters. Article 166 sets out the rules for how the business of the state government is conducted, ensuring that all executive actions are taken in the name of the governor. Finally, Article 167 outlines the duties of the Chief Minister, which includes communicating all decisions of the Council of Ministers to the governor. This ensures the governor is always kept in the loop. Next, we move to the state legislature, covered from Articles 168 to 212. Article 168 specifies that a state legislature can be either with just a legislative assembly, or bicameral, with both a legislative assembly and a legislative council. Article 169 gives Parliament the power to create or abolish a legislative council in a state if the state's legislative assembly passes a resolution to that effect with a special majority. The composition of the legislative assembly, or Bidang Sabha, is detailed in Article 170, with seats allocated based on population. Article 171 explains the composition of the Legislative Council, or Vidhan Parishad, which has members from various fields, like local bodies, graduates, teachers, and nominees of the governor. The duration of the assembly is 5 years, as per Article 172, unless it's dissolved earlier. This is where the anti-defection law, upheld in the Quixote-Halahan case, becomes relevant. To be a member, Article 173 sets the age qualification at 25 for an MLA and 34 in MLC. The governor's role continues with the legislature. Article 174 empowers the governor to summon, prorogue, and dissolve the assembly. The Nabamribia case again made it clear that the governor cannot summon the assembly without the chief minister as advice. Articles 175 and 176 deal with the governor's right to address the legislature, including the special address at the beginning of each year. Article 177 gives ministers and the Advocate General the right to speak in the House, even if they aren't members, but they cannot vote. Articles 178 to 187 cover the roles and powers of the presiding officers, the Speaker, Deputy Speaker, Chairman, and Deputy Chairman, and the legislature's Secretariat. Members must take an oath under Article 188 before taking their seats. Article 189 outlines the voting procedure, which is usually a simple majority, and the quorum required for the House to conduct business. Articles 190 to 193 detail the grounds for disqualification of members, such as holding an office of profit or defection. The Quixote-Halahan case established the Speaker as the final authority in defection matters. Legislatures enjoy certain privileges. Article 194 guarantees freedom of speech within the House. This was famously upheld in the Searchlight case of 1959. The legislative process itself, from passing bills to handling financial matters like the budget, is covered in Articles 196 to 207. Each House makes its own rules of procedure under Article 208. To maintain the separation of powers, Article 211 prohibits discussion on the conduct of judges, and Article 212 prevents courts from questioning the validity of legislative proceedings. What happens when the legislature isn't in session but a law is urgently needed? Article 213 gives the governor the power to issue ordinances. However, the Krishna Kumar Singh case of 2017 warned that this power cannot be misused by repeatedly repromulgating ordinances without getting legislative approval. Now, let's turn to the third pillar of state governance, the judiciary, starting with the high courts from Articles 214 to 231. Article 214 mandates a high court for each state, although Article 231 allows for a common high court for 2 or more states. Article 215 declares the high court to be a court of record, which means it has the power to punish for its own contempt. The appointment of high court judges is done by the president under Article 217, following a consultation process that evolved into the collegium system after the second judge's case in 1993. Article 226 is one of the most powerful provisions, granting high courts the jurisdiction to issue writs like habeas corpus, mandamus, and certiorari, not just for enforcing fundamental rights, but for any other purpose. The Alchandra Kumar case declared this writ jurisdiction to be a part of the Constitution's basic structure, which cannot be taken away. More. Article 227 gives high courts the power of superintendence over all subordinate courts and tribunals within their jurisdiction. Article 228 allows the high court to withdraw cases from subordinate courts if they involve a substantial question of constitutional law. Finally, we have the subordinate courts, covered in Articles 233 to 237. This section ensures the independence of the lower judiciary. Article 233 states that the appointment of district judges is made by the governor in consultation with the High Court. The Chandra Mohan case emphasized that the executive cannot bypass the High Court S rule in these appointments. Article 235 gives the High Court complete control over the subordinate judiciary, including posting, promotion, and granting leave to judicial officers. This control was affirmed in the State of Assam versus Ranga Mohammed case. This structure ensures that the judiciary at the state level remains independent and efficient. And that's a comprehensive overview of Part 6 of the Indian Constitution. We've covered the State Executive, Legislature, and Judiciary, understanding how these three branches work together to govern our states. It's a complex, but beautifully designed system of checks and balances. I hope this breakdown was helpful and gave you a clearer picture of state governance in India. If you found this video useful, please give it a thumbs up, share it with others, and don't forget to subscribe for more deep dives into the Indian Constitution. Thanks for watching, and I'll see you in the next video.